Well, my concept of
Of course,
justice.
I'm warning you that was it Disraeli who said that if you define justice, you limit it. And
Yes, Your Honor.
if you limit it, you destroy it. Anyway, uh, Chief Justice Laurel has already defined what is social justice. What is your concept of justice?
My concept of justice is something concrete, something that the people can see happening in reality, not just a lofty ideal, not just something we strive for endlessly without ever experiencing it, but something that they can feel in their hands, that they have been aggrieved, therefore they have managed to get justice from the courts. To me, that would be the greatest legacy that anyone, in particular, could leave with the court.
As a magistrate, Gene, you decide cases on the basis of law.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
Based on the facts, considering the facts in a certain case and the law involved. Now, considering the motto of the integrated bar of the Philippines, if the law is not in accordance with your conscience, will you abide by the law?
As a judge, I would have no choice but to abide by the law. But of course, how I would interpret the law would have to depend on what is available to me in that particular case. If I feel that, as provided in our rules and in our law, when a judge feels that the law he is applying is unjust, is unfair, then he can do everything he can to appeal to the proper body to repeal that law.
If the law is not in accordance with your concept of justice, will you abide by the law?
It's very difficult to answer that in the abstract. In fact, it's hard for me to conceive of a situation like that, except perhaps if it comes from if it's a corrupt order. Then if it's a corrupt order, then I think that that's not an order that ought to be abided by, Your Honor.
Dean, when you enter the portals of the Supreme Court of the United States, you can see emblazoned there the words equality under law. Perhaps a revelation of the court's judicial philosophy. Here, in the Supreme Court of the Philippines, what do you have? Batas, Bayan. No, so in short, what can be your judicial philosophy?
My judicial
If you
philosophy.
have to, if you have these phrases as a paragon.
My judicial philosophy, Your Honor, as I said earlier, would be to concentrate on delivery of justice, especially to the masses who comprise our population, finding all the different ways and means that we can make justice real to them rather than just a dream, finding ways to give them more access to lawyers, finding ways to give them more access to the courts, because the sad truth is that many of our courts, it's just too expensive for many of our people to litigate cases. Even cases that are very strong, cases that are meritorious but lack the proper resources on the part of the litigants, very often they don't end up prospering because of the situation.
Dean, you've never been a magistrate before.
No, Your Honor.
Not a judge, not a justice. Will you not find it difficult to go directly to the position of Chief Justice without passing through the Associate Justice or even RTC judges, MTC judges?
It will definitely be a challenge, but I would like to say that I have been going to court for more than 20 years, and from what I've seen, there have been some excellent justices who came straight from private practice. The beauty of it, Your Honor, is that I have seen how justice works firsthand at close range. I've seen it in the lowest of the lowest courts up to the highest of the highest courts. So I would like to bring that experience to the court if I can.
Well, that experience as an advocate, John.
Yes, Your Honor.
You can see that there's a whale of difference between your experience as an advocate and your experience as a magistrate.
Yes, there is a very big difference, and I would have to make sure that I will rid myself of the advocate's attitude if ever I am appointed to the court.
On that note, thank you very much.
Thank you, Justice.
Secretary Mosni.
Thank you, Mr. Chairman. I'd like to say first that I'm happy to know that the LaSalle program rests in your very good, capable hands.
Thank you.
Dean Jokno, do you consider yourself a religious person?
Perhaps spiritual might be closer to it, although I would not want to even claim to that term.
In that sense, do you think that religiosity or spirituality has a role to play in the dispensation and administration of justice?
Definitely, Your Honor. I think that it does. Because one's values really they spring not really from ourselves, but from something we see as higher than us. And when judges especially understand that they are not the highest law and that they must also bow to a higher law in the universe, then of course their decisions will be tempered.
All right. My next question is recognizing the present stage of our democratic space. Which do you prefer? Judicial activism or judicial restraint?
I think there is, at the present time, a need for more activism on the court.
Can you kindly explain
Yes.
further?
We are in a situation where we don't have yet a proper legal framework for the delivery of justice to the masses in our country. And for us to just sit back and take a more safe or conservative attitude, given that situation, I think would not benefit the people whom we are here to serve. I would say that as far as improvements in terms of the uplifting the minimum standards of people are concerned, labor and other sectors who are vulnerable in our country, then I would be inclined toward a judicial activism.
Who among the chief justices that we have had before do you think has left a judicial legacy that is worth emulating? What do you think would that legacy be?
One of the justices whom I really admire is Justice J.B.L. Reyes. And if ever, I would like to emulate him, both as a man and both as a jurist. Up to now, I'm still very amazed when I read his decisions because hangang-hanga po ako as far as his judicial statesmanship are concerned. I'm sure there have been other good jurists as well, but it's also because perhaps I was able to meet him in person up close, and that's why I feel some affinity toward him.
Yes, thank you, Attorney Jokno. But is there any chief justice in mind that you have worth emulating with a legacy?
At the moment, Your Honor, I'm not sure I can think of any.
My last question, Mr. Chairman, is this. What is your position in this? Should the President be presumed to have residual powers other than those stated in the Constitution or specified in the Constitution?
Residual powers in what respect, sir, if I may ask?
Do you think that the provision allowing residual powers to be maintained and retained by the Office of the President is a correct concept in law in our time still?
If you're referring to what is contained in the revised administrative code, and if I'm not mistaken, what has been the subject of some legal debate, I think there is a danger in the exercise or in the use of that concept of residual powers, in the sense that, and I'm not referring to anyone in particular at present, but that may be or may tend to be abused. We are a highly regulated society. Most of everything that the President has to do is already provided either in the administrative code, in special laws, or in executive issuances. So I'm not sure really if there's a real need, except maybe in a very, very small class of cases. Areas where there is an obvious gap in the law and nothing beyond that, but simply for the president to act because there is no statutory regulation.
Thank you, Mr. Chairman. That will be all. Thank you very much.
Thank you, sir.
Perhaps the Honorable Frederick Musni refers to the late Chief Justice Fernan.
Now, just a few questions, Dean. You are a known advocate of human rights.
Yes, Your Honor.
You are likewise a defender of persons involving human rights.
Yes, Your Honor.
Now, you are aware of the rulemaking power of the Supreme Court
Yes, sir.
for the protection of and enforcement of human rights.
The writ of amparo and the writ of habeas
In
data.
fact, that's the product. The product of that rulemaking power, or the products would be the writ of amparo and writ of habeas data.
And the rule on the environmental cases, Your Honor.
Oh, okay. Now, my question is, you joined the Supreme Court as Chief Justice. Do you have rules in mind that you would like to introduce for the protection of human rights other than those that we have now, the writ of amparo and the writ of habeas data?
Well, before I would even get to that, Your Honor, I would first revisit the existing rules on the writ of amparo and habeas data and gather there have been a lot of inputs already from the practitioners as far as suggestions to improve those rules are concerned. If I'm not mistaken, even FLAG has submitted some proposals to the court. I think that the Chief Justice should look into that first, improve where it needs improvement, and when that is already working in a very good manner, at that point perhaps it would be good to look at further rules. At present, I think we have enough rules, Your Honor, to deal with our cases.
Yeah, I think you also submitted your suggestions for the possible incorporation of those rules
Yes,
in our
even-
existing rule. No?
Even the perpetuation of testimonies, we
Yeah,
have
okay.
submitted that, Your Honor.
Now, you were also talking about there is no need to amend the rules. Did I get you right? In order to expedite the termination of cases, there is no need to amend the rule except the some rules on evidence.
I believe my answer was there's no need to issue new rules. However,
Yeah.
with respect to the existing procedures in court, there are a number of changes I would like to see.
And then particularly, you were referring to the admissibility of evidence.
Yes, Your Honor.
So you are suggesting an amendment or probably amendment to the rules on evidence.
But perhaps not even an amendment, simply a directive or a circular to trial judges to make specific evidentiary rulings when offers of evidence are made. Because the problem, Your Honor, is many of our courts or lower judges, in my experience at least, in criminal cases, they will wait until the end of the case. Then they will decide on the outcome. Is this person guilty or not? If they believe he's guilty, then they will make the evidence, they will make the ruling on the evidence consistent with the outcome that they desire. Now, if we require the judges to rule on the evidence at the middle of the trial, then everyone, even the judge, will be bound by that in resolving in deciding the case at the end.
But in that particular case, if the evidence is not offered, then there's no evidence to admit, and the offer is only made at the time the prosecution or the accused rests its
Yes.
case. So probably the court cannot rule on the admissibility of evidence during the trial because there is nothing yet to rule on because there is no yet offer.
Well, when the offer
Probably
is...
what you're talking about is that we allow the suppression of evidence even before
That
the
is
prosecution
another,
rests. I think that's what you're saying.
that is another proposal, Your Honor.
So you are also agreeable to the suppression of evidence in the pre-trial proper.
There should be a pretrial motion which allows the judge to rule on evidentiary issues, for example, that involve
Without-
constitutional matters, Your Honor.
So without waiting for the offer of that evidence.
Yes.
I think that can be done during pre-trial.
That can be done during pretrial. It's as a practice, however, it is not employed by...
Do you agree that the
the lawyers.
pre-trial, therefore, is a good rule because it actually helps the early disposition of the case in pre-trial?
Yes, especially, Your Honor, if the pretrial is managed very well by the trial judge, then it becomes an excellent tool for facilitating the case.
So it's a question of so who is the judge presiding in that court, not a question of the rules actually.
Well, it's a question, Your Honor, as well of the skill and expertise of the judge. As I recall, when I appeared in the Sandigan Bayan before the late Justice Garchitorena, when we would conduct pre-trial, alam na alam po niya yung kaso. He had read the record fully well, so that pag nambobola po yung abogado at sabihin niya ayaw niyang aminin, sinasabihan siya ni Justice, paano mo hindi mo aaminin yan? Sa preliminary investigation, inamin mo na yan. The problem with other courts where I have appeared is that the judges are not as active in understanding the record and in making sure that the parties will stipulate the facts that should really be admitted already.
Noong panahon ni Justice Hermosissima, ganun din eh. Stricto rin sa pre-trial Sandigan eh. Si Justice Bobby Lagman, the husband of Justice Auring Lagman, ganun din, stricto rin sa pre-trial eh. Ganun din sa akin eh, when I was presiding eh. Yeah.
Yes,
Now,
Your
the
Honor.
other question that I would like to ask is, of course, you are against the reimposition of the penalty of death. You are also the view that it's not a deterrent to the commission of heinous crimes. Now, as Chief Justice, if you are appointed Chief Justice, what rules would you like to introduce in order to deter the commission of heinous crimes? Because you are against the imposition of the death penalty and it's not a deterrent. Can you think of something, a rule that would be promulgated by the court?
I think the problem really
Again,
is...
under the rule-making power of the court?
In order to address that issue, Your Honor, I would want to make sure that the courts can deliver justice, meaning that they are capable of deciding these cases in a manner that is swift and yet fair. Yeah. And I don't think any special or particular rules will be necessary, except to ensure that the courts do their job.
Yeah. Now, you were also saying that judgment is already final and executory. You were saying that accused who are already convicted by final judgment, they do not actually serve their sentences in the national penitentiary. Did I get you right? You were quoting
yes, Your Honor.
you were quoting a data. Is that the fault of the court?
No, Your Honor, I'm not saying
it's
it's
not
the fault of the court. I'm just saying that it is a problem that everyone
Must be addressed.
should address.
Must be addressed. I think the problem there is that these accused are entitled to bail even pending appeal, because these offenses, like the anti-graft, you were referring cases before the Sandigan Bayan, there are only a few cases that are non-bailable. Probably plunder. I think that's the only crime under the anti-graft that is where bail is not a matter of right. All the other cases that are filed against government officials are all bailable.
Kasi mababa
So if the
po ang
cases
penalty.
are reached the Supreme Court and the accused is out on bail, and when judgment comes, and then a warrant of arrest is issued, that accused can no longer be found.
Yes.
So that's not the concern of the court. It is rather the concern of the executive, because their duty is to arrest fugitives. Is it not?
Directly po, it's not a concern of the court, but indirectly it concerns accountability. And I think that that's a concern of every member of the government, whether judicial or executive.
I was
or
also listening to you about cheaper justice, no? Cheaper justice. Is it your view that the fees being collected by the court are exorbitant
No, Your Honor.
and therefore beyond the reach of poor litigants?
My view is that we should look at the rule on pauper litigants and make sure that all trial judges understand now that the rule is you don't need to strictly apply Rule 141 as long as they can comply with Rule 3, Section 3.
Yeah, I had to tell you that because some of the fees that come from Rule 141, no? The fees that we collect actually are fees that are allowed under Rule 141 of the Rules of Court. And the fees that are collected are part of what we call the Judiciary Development Fund, or
Yes,
JDF, no?
JDF.
Which is a law, which is actually a law. The other fees collected go to what we call the SADS under RA 9227.
Just-
All these funds are distributed to the employees. The JDF is on a pro rata basis. the lowest ranking employee of the court will get a higher allowance than the justices of the Supreme Court. The such allowance is an allowance to augment whatever judges receive from the GAA or the Appropriation Act.
Yes.
So if you reduce the fees that are collected you can just imagine what will happen to the employees who are already enjoying these allowances. Now you were also talking about flip-flopping decisions. What do you understand by flip-flopping decisions?
Well, my understanding, Your Honor, is cases that are already final in nature,
Oh.
where judgment has become final and executory.
But when a decision is rendered and it is reversed by virtue of a motion for reconsideration, that is not flip-flopping.
Hindi pa po, dahil
Hindi
the
pa, oh.
judgment is not yet final.
And if that case, again, is the subject matter of a motion for reconsideration, because the winning party will now become the losing party in a motion for reconsideration, and the court will reconsider its decision, that is not also flip-flopping.
No, Your Honor, it's
Yeah.
not.
Yeah, so that so that the public may know what is actually flip-flopping. Your definition of a flip-flopping is that if a judgment has already become final executory, then the court should no longer entertain any motion to revive that decision. That's what you're saying.
Yes, Your Honor.
But are you aware that even judgment of the lower courts may be the subject matter of a petition for relief from judgment, although the judgment have already become final executory? Or are you aware of a petition in the rules of court, a petition to annul a judgment due to fraud, extrinsic
Yes,
fraud?
Your Honor. Yes, that is
So why do
recognized.
you
Yes.
prevent then the Supreme Court from re-examining a decision that they have already rendered, which has already become final executory, when the Court of Appeals and when the Court of Appeals can entertain a petition to annul a judgment?
Two reasons, Your Honor. First, because the Supreme Court is the highest court of the land, and the buck should stop with the Supreme Court. Second, Your Honor, I see the practice as very pernicious as far as the court is concerned, because it leaves a bad taste in the eyes of the public. It does not add to the credibility of the court. I would rather have a system where, right or wrong, a decision is final, judgment has already become final, the parties have exhausted all remedies to question that ruling, then let's leave it and move on.
Anyway, probably you can only cite few cases, no, where the Supreme Court entertained a motion to revive, no.
Yes, Your Honor.
So I think it's only 2 or 3. How many?
Several. I'm not
Yeah,
sure
only
of the
two.
number,
I
Your
think
Honor.
only 2 or 3. There was a wrong notion that in that case of FASAP, the Supreme Court flip-flopped. That's not true. We have not yet decided the case actually. Probably you're referring to a case. So anyway, we agreed that when a motion for reconciliation is granted, then that's not flip-flopping, you know. Okay.
Yes, Your Honor.
Now you were also talking about the process of appointment of judges. Is it really a problem in the appointment of judges? Are you not satisfied with the process being conducted by the Judicial Bar Council? Then later on, nominations are the names of nominees are forwarded to the Office of the President for appointment?
I'm not referring to the present Judicial and
Oh.
Bar Council, Your Honor, but I have heard, although I have no personal knowledge myself, of a lot of horror stories perhaps that came out from the previous administrations. And I think that perhaps that is what should be stopped.
So it is your contention that the JBC should be retained?
I think we should be looking towards the future and looking beyond the JBC. I think there are ways that of choosing judges that are much less political in nature and more democratic. I think we should allow other sectors of our society, not only members of the bar, to select the members of the judiciary.
So your suggestion that non-lawyers should be included in the choice of judges?
Palagi ko po dapat din.
Dapat, ano?
Opo.
Dapat. Pati farmer, pwede na maril mag-join, ano?
Well, everyone has a stake in the justice system, Your Honor, the poor as well as the rich.
Okay, sige, that's all? Yeah, you have other questions?
May one.
Go ahead, Justice
You're
Hermosisima.
talking, Dean, you were talking of the great vacancies in the judiciary. in the lower courts, for example. The reason for this is in places like Sulu, Tawi-Tawi, Samar, and other places that are plagued by recalcitrant elements, there are no applicants. And then there is another thing. There are courts that are created by Congress in remote areas. And so these courts, in these courts, we do not nominate because there are no cases. So that's the problem. That's the reason for the great number of vacant courts. You see, when a congressman creates a court in his district, but it's in a remote place, that's an achievement on his part. But then he does not think that there are no cases in these remote areas. So think of the vacancies. As a matter of fact, we are recommending that these courts that are in remote places be brought to Manila and other urban cities like Cebu and these places.
Yes.
Because here in Metro Manila, for example, we need a lot of courts, more judges. But in these remote areas, that should be removed and placed here. When I was appointed to the Judicial and Bar Council, the vacancy was 19%. Now it's 27%. But those are the reasons for the great number of vacant courts.
Yes, Your Honor.
Thank you very much.
Okay, we are through. Dean Jokno, thank you for coming.
Thank you, Your Honor.
You're welcome. May we have the next candidate?
Kaya nagtagal po ng mahigit isang oras itong pag-interview sa isa pang nominee na si Jose Manuel Chel Jokno, isang human rights lawyer at founding dean ng De La Salle University College of Law. Kung napansin niyo po, wala si Congressman Neil Tupas doon sa mga nagtatanong because he said he had to leave. Meron daw siyang session na kailangan daluhan. However, itong ang nangyari, pinaubaya daw sa kanya ni Senator Chis Escudero ang pagtatanong until Friday kasi nag-file na sila ng motion for reconsideration dyan sa Supreme Court regarding dito sa dapat dalawa para sa kanila ang umupo dyan sa JBC. Well, in the meantime, kasama pa rin po natin si Attorney Cynthia Rojas, isang litigator. Welcome back po. And ito pinag-usapan nila, yung nais na reformang ipatupad ni Jokno kapag siya ang naupong Chief Justice. Kabilang dito yung pagtatalaga ng sibilyano, not necessarily lawyer daw, dito sa JBC para sa pagpili ng punong maestrado. What do you think about that?
I think the reason why he said it earlier that all persons, civilians included, are stakeholders in the justice system, di ba? Kaya lang, kung mapapansin nyo, yung sa regular members, meron dyan representative from the judiciary, from the academe, from the civil sector. So, nagkataon lang siguro na abogado din. But I think, sila lang ang tinalaga, nagkataon abogado sila. But I don't think it should be limited to that. I think that everyone, and this process na nagkakaroon ng televised question and answers para sa nominees, I think it's a nice improvement para dun sa sinusulong na judicial reforms. Para lahat ng tao nakakaalam kung ano nangyayari sa ating judicial system.
At sa nakita nga natin from this morning, hindi biro ang prosesong ito sa mga nakasalang na mga nominees. Diyan nakaupo at yung mga katanungan at ano, I could just imagine yung pressure.
Yeah, but you have to, I think from the kinds of questions that are being asked, these are all sorts of questions, not just legal questions which are posed upon the applicants themselves. So I think it's a whole range of questions, and I wouldn't doubt kung yung mga ibang normal na tao or mga man on the street, kumuha yung mga members ng JBC ask for these questions.
Okay, babalikan lang
from
natin
tao.
yung Senado, Supreme Court ngayon because right now nakaupo na po si Francis Hardelesa, ang Solicitor General. The next, this is the fifth nominee na interviewin ng Judicial and Bar Council. Narito po.
Independence, fairness, integrity, and probity. To be worthy of respect, the Supreme Court must speak in a clear and compelling voice through every decision. And what is a judicial decision? It is a well-considered and well-reasoned conclusion arrived after hearing adversarial positions, to which is applied the test of logic and evidence governed by the spirit and letter of the law. It is thus very crucial, as a commentator noted, that legal reasoning be, and I quote, marked by its own integrity, close quote. This built-in theory of integrity of every judicial decision is so essential, it becomes the law's, and I quote, internal accountability, close quote. I fully subscribe to this insight and embrace it as my philosophy about the role of the judiciary. Without that integrity and accountability, the rule of law will collapse. Thus, whether one is liberal or conservative, whether an activist or a proponent of self-restraint, at the end of the day, the rule of law requires and plainly means that decisions of the Supreme Court must be products of careful legal reasoning and accepted and understood as such by the people. Having said that, my vision for the judiciary is an independent, equal branch of government that earns the trust of the people as guardian of the rule of law. It dispenses fair, equal, and responsive justice. It lives by its core values of fairness, accountability, and independence. This vision will be my guiding faith in the formulation of reforms in three priority areas: reaffirmation of the rule of law, effective administration of justice, and accountability and transparency. Thank you, Mr. Chairman.
Attorney Cayosa?
Thank you, Justice Peralta. Good afternoon, Solicitor General Francis Hardelesa.
Good afternoon, ma'am.
We have seen you here before, the first time when you were being considered for the Supreme Court, but as an Associate Justice then, and for the offices of the Ombudsman and Deputy Ombudsman for Luzon. Now, since the time you assumed as Deputy Ombudsman, could you tell the Council what you have accomplished as Deputy Ombudsman for Luzon, which you feel prepared you for the position of Chief Justice?
Yes, ma'am. I spent 7 months in the office of the Deputy Ombudsman for Luzon. And before I left, two of the most important projects I had was to craft proposed office policies on, number one, what we call the filtering of cases, and number two, rules to govern the exercise of discretion of our officers. What was filtering of cases all about? We realized, ma'am, that in the office of the Ombudsman, it was swamped with so many cases, such that the priority governed by statute, which is to prioritize high-profile cases involving high government officials and large amounts of money, were not being attended to because cases big and small were just given the same attention. And so we attempted to put up what we call a filter system. One of the most nefarious practices in government agencies is parties and even lawyers do not anymore know how to appeal. For example, a litigant is not happy with the decision of a prosecutor or the decision of a labor arbiter or the decision of a register of deeds. Instead of appeal, many times they will go to the ombudsman and craft an anti-graft complaint. This is so pervasive in the office of the ombudsman that there are so many cases where even on first blush, a well-thinking officer will know that this should not go, if you may say, past first base. And so it was very important for us to have the so-called filter system. And so with the filter system, I placed a very responsible, high-ranking officer to be a permanent watch so that as the cases come, based on certain guidelines, we are able to throw out at an early stage cases which should not take the time and resources of the ombudsman. I'm very happy that just before I left the ombudsman, I was able to have a bureau to take care of this filtering system, and to the best of my knowledge, ma'am, it is now working.
Do you have statistics to show that this filtering system has actually been effective in reducing the docket?
I do not have the statistics on hand, ma'am, but it is anecdotal, and when I compare notes with my colleagues, they are happy that they are doing their share of filtering the cases.
If you were to translate what you did in the office of the ombudsman to the trial court setting, how would you do that?
I would venture that, again, the judges at the first, second level courts especially, with the proper training, should be probably a little bit more proactive to control the dockets by requiring the litigants to really come up with meritorious cases. I always go back to one of the rules of procedure that when an attorney signs a pleading, it is a certification by him, by that attorney under his oath, that there is merit in that claim. And too often, I think, probably many litigants and many lawyers are not very conscious of this. And with the help of the courts, with the help of the bar, we can have a system where many of the more cases without really merit should not tax the energies of our court. And one of my favorite themes, just like in the ombudsman, is what I call, ma'am, abuse of process. Many litigants, again, and many lawyers just file many cases. And typically, again, in the trial courts, for example, disbarment cases, instead of going up on certiorari, again, litigants or lawyers will file disbarment, file anti-graft, and really this clog up the courts. When I was in the ombudsman, I realized that if a government employee, a lowly one at that, has a pending ombudsman case, that person cannot travel, cannot be promoted, cannot retire. And many of the cases should not have been brought there in the first place. There is always appeal. There is always certiorari. And I think there has been too much resort to remedies other than what is in good faith should be a remedy of a litigant or a member of the court.
After you had gone through the Judicial and Bar Council process for the offices of Ombudsman and Deputy Ombudsman for Luzon, we were quite surprised that you actually accepted to be appointed to the Office of the Solicitor General. What made you accept that position?
The Office of the Deputy Ombudsman, Madam, yes, it is true, has a 7-year tenure.